Well, thank you all for having me. As you heard, my name is Greg Parker. I am a shareholder and owner of the Parker-Justiss law firm in Dallas. We are strictly an intellectual property law firm, so we deal in, you'll see here in a second, but primarily patents, trademarks, copyrights, and the such. We do both the obtaining or preparation and prosecution of patents and trademarks, as well as some litigation along those lines. But as you see today, I was just going to run you through a little bit of a nutshell of intellectual property, and as we move through, I'm going to try and give some time towards the end for you to ask any questions you may have. So don't hesitate when we get to the end. Please, we'd love to have you ask questions. To the extent I can, I'll answer them. And generally, just let's have this a kind of an open forum for questions. But we'll do those questions at the end. So, and I've been practicing patent law and intellectual property law for about 18 years now, 18, 19 years now. So, fairly versed in the law. But anyways, we're going to start with standard attorney disclaimer. Not providing any legal advice here. We're just friends talking, essentially. So, if you have questions in the end, feel free to ask. But there's not an attorney-client relationship. But as we move forward, intellectual property, there are basically 5-6 main types. We focus mainly on patents as individuals, as corporations, but there are also trademarks, copyrights, trade secrets, trade dress for the most part. We're going to focus this discussion, if we may, on the patent side, which I think most corporations will devote the time, energy, and money towards as you get out of engineering school, maybe become a starting engineer working for a corporation, or maybe even start your own company. Patents are really the foundation of an engineering or high-tech company. So I want to focus most of my time on that. But trademarks and copyrights are also important, as well as trade secrets and trade dress. So, patents. What do we have? There are essentially 3 types of patents. You have utility patents, you have design patents, and plant patents. We're going to focus for the time on utility patents. So, to get a utility patent, there are provisional patents and non-provisional patents. A provisional patent is kind of a pro forma description of your invention that you may file with the Patent and Trademark Office. It gets you a first filing date. When most people think of patents, they think of utility patents and non-provisional patents. So, or we'll call them regular patents. To get one, under 35 U.S.C. 101, it requires that your idea be new, useful, and not obvious. Again, utility patents protect machines, processes, methods, articles of manufacture, compositions of matter, and software. Software. Difficult. When you get a software patent, it's really not a software patent per se, but it has to be tied to a tangible medium such as a hard drive, a computer. Something has to be doing that work, or it's not entitled to patentability these days. When you get a patent, it is a property right. I don't know, for many of you, young students, you might not own a home yet, but once you do, that is real property. You own real property when you own a home. If you were to purchase the home, they would find little stakes in the ground at the front of the property, at the back of the property. If it's shaped like a rectangle, you could take a piece of string and connect those 4 points, and everything within there you would own. That's your real property. Intellectual property is just the same. We'll set those stakes. We use words to set those stakes. And once you use those words to set those stakes, and your patent issues, that is your intellectual property as opposed to real property. But it is a property right and is assignable. You have inventors of patents. You have owners of patents. Sometimes the inventors are the owners. Sometimes the inventors are not the owners. So, the term of a utility patent is 20 years from the earliest effective filing date. So if we were to file a patent on January 1st, 2018, it would be, the term for that patent would generally run 20 years later. It may take 3 to 5 years, as you'll see, for you to get a patent through the Patent and Trademark Office. such that you can enforce it, essentially you lost those 3 to 5 years of your term, but in the end, you will get to move forward for the following 17 or 15 years, whatever it might be. What are a patentee's rights? A lot of times people get confused with a patent. Does a patent allow you the right to do something? No. When you're talking about patentability and infringement, those are two separate paths of thought. You would wear two separate hats if you're going to be looking at patentability or infringement. What does a patent allow you to do? It allows you to exclude others from doing something. Again, it does not give you the right to do something. It gives you the right to exclude others from making, using, selling, offering to sell, and importing the invention within the United States. Again, you can prevent others from making, using, selling, or offering for sale, or importing into the United States. But it does not allow you the right to do so. We'll talk about that here in a second. So let me give you an example. If inventor A invents a bicycle without brakes, and inventor B invents a brake for a bicycle, neither one of those can practice that invention, even though they have a patent, without the other one's permission. I know that that's a little difficult to understand, but if you just really take this to heart, that a patent does not allow you the right to do something, it allows you the right to exclude others from doing something, then that makes sense. Because the reason for the patent system is to foster innovation. They will give you that 20-year, effectively a monopoly, to move forward if you will put it out onto the public. Your patent is public once it issues, and others are able to use that idea and grow that idea, and hopefully new innovations come from it. So moving on. When should a patent be filed? In all honesty, we talked about this earlier when I was talking to some of the faculty, and best case scenario, you file your patent, whether it's a provisional or non-provisional patent, as soon as you can. It is just best practice. Get that thing on file. One, it gets you a filing date, which is kind of a stakeholder, and someone else can't sweep in behind you and patent the same thing. Two, it gets your ideas down on paper and gets it solidified, really what your idea is. And so it's just really important to do so. So if you look right here, the American Invents Act, which was signed in September of 2011 and enacted in 2013, changed what used to be the rules in the United States. In the United States, if you developed an idea, thought of it, invented it, but never filed a patent on it, someone else comes along, files a patent on it, you could go back and say, hey, wait a minute, I was the first to invent. You can essentially take that person's patent and it becomes yours because you were the first to invent. You have to show that you did invent it. You have to show that you were reasonable in the time frame between inventing it and patenting it. But you could go back and take that from them. In 2013, the United States changed their laws. And to be honest, it now tracks what foreign countries do. It is a first inventor to file. So if we both came up with an idea on our own, not stealing it from someone else, and they filed it first, it doesn't matter whether you thought of it 6 months, 2 years before. First inventor to file nowadays. So in the United States, and this is important to know, back to when should it be filed, you have a 1-year provision where you need to get your patent application on file within 1 year of making that idea public. Okay? What does that allow you to do? As a small business, as an individual inventor, that allows you to maybe market the idea, manufacture it, potentially go out and sell the idea for 1 year before you have to have your patent application on file. Again, do I suggest that we do that as an inventor? No. But I do recognize that patents are expensive, they're time-consuming, and not everyone has the money to go get that patent application on file prior to trying to sell the idea. So the United States has this 1-year provision. And so, but if you do not get your patent application on file within that 1 year, you're barred. There's a statutory bar from you filing that patent application, and you've dedicated that idea to the public. So, but it says, but beware, if public disclosure or offer to sell is made before filing a patent application, almost all foreign rights are forfeited because of the public disclosure or offer to sell. Most jurisdictions around the world do not have this 1 year provision. So keep that in mind. You know, again, best case scenario, best practice, get that patent application on file as quickly as possible. How to protect before filing. You need to keep it secret. Again, public disclosure starts at 1 year, that 1 year term. If you can just keep it secret, great. Maybe you can show it to someone under a non-disclosure agreement. If it's under a non-disclosure agreement, that person has an obligation to keep it private. Therefore, it does not start the 1 year term. You can probably make a careful written description, including drawings, and have it witnessed by someone under a non-disclosure agreement. Again, you're just wanting to get that down on paper, have a third party sign it, and date it, and therefore you have this just written form of what your idea is. Or, best case, if you're not going to be able to file the non-provisional, you go ahead and file the provisional patent application. What is a provisional? So a provisional patent application is essentially a, you know, for example, if you're a student or faculty and you've written a paper and you're wanting to disclose that paper, publish it somewhere, you could use that paper as your provisional application. File it with the Patent and Trademark Office. Provisional is not going to have you know, many of the things that a traditional regular application would have. It won't have formal patent claims. Again, I talked to you about those stakes that you can use in intellectual property to define your invention. Those are the claims of the patent. It will not have an oath or declaration. You won't talk about the prior art therein. So essentially, it is something that can be prepared by the inventor themselves, reviewed by an attorney would be best, and filed for, you know, relatively little money compared to what a non-provisional or regular application might cost. That said, when you file that provisional application, it still must contain a thorough written description and any relevant drawings. Best case, more detail is better. You know, it says the more detail is better because anything that has to be added when it is converted from the provisional to the non-provisional, if you need that information, you can add it, but you lose that effective filing date. So, again, you know, you have this scale where you're trying to weigh, hey, I want to get my provisional patent application on file, but I don't have everything tied down. So you have to just kind of weigh, is it better to wait 1 month, 2 months, 3 months to get more information, and therefore you have all your information in the provisional, or is it better to get that stake in the sand so that you don't have to worry about others? Again, individual can prepare it, but it's best to be reviewed by patent counsel, and best practice is that it provides the means to establish an early effective filing date without the substantial expense associated with a regular application. Again, suited for individuals because of the reduced expense. It gives you that 1 year. It also allows you to put the term patent pending on any product that you may be associating it with. And but a provisional application will never issue into a patent. You have to convert that provisional to a non-provisional and go through the prosecution process before the United States Patent and Trademark Office before you have any property rights. And then that's where it says right here, within 1 year, you must convert that provisional to a non-provisional. How much does it cost? You know, depends on whether you're talking provisional or non-provisional. Provisional applications, the cost there depends on how much involvement the inventor is going to have. If per se it was a published paper that someone had written, and we were just filing that as a provisional application, and the attorney time would be limited, you're probably talking $1,500 to $2,000 to get that on file, maybe even less. It just depends. Now, when you convert that, or if you file a regular application, the cost goes up quite significantly. You should expect for the attorney's fees and the filing fees to be between $8,000 and $12,000 just to get that patent application on file. And you know, again, we have that 1 year provision to start manufacturing, selling, marketing, And it really is to offset this $8,000, $12,000, because that is an upfront fee that you will spend to get that patent application on file. And the Patent and Trademark Office isn't going to pick up that file for 2, sometimes 3 years. So you're going to be putting lots of money up front, and we recognize that in the United States, so they give you that 1-year period to hopefully, manufacture it, sell it, make some money. And then it says right here that this is only for filing, does not include the cost associated with prosecution. The general process for filing a patent and getting it issued is you file it day 1, 18 to 36 months later, the United States Patent and Trademark Office, called the USPTO for short, will pick it up, they will examine it, you will negotiate back and forth about the claim scope, where you put those words, the stakes in the sand for your claims. And the patent office they're going to always say your patent or your idea is not patentable, it's not novel, someone else thought of your idea first, or it's obvious. You're taking 2 known things, throwing them together, that is just obvious. Well, our job as patent attorneys and patent agents is to negotiate, argue, better term, with the United States Patent and Trademark Office and convince them that the idea is patentable. That process can almost eclipse the cost of getting that patent application on file. So, if you're thinking about worst case, maybe not worst, average to worst case scenario of how much you might be out of pocket if you're an individual or a small corporation or even a large corporation. I mean, they have lots of funds to devote, but you'd be looking at probably anywhere from $15,000 to $25,000 per patent by the time you get an issued patent. And nothing's guaranteed. Many times you'll go through that $25,000 process and just honestly cry, uncle, I'm out. I can't spend any more money. Or they convince you that it's not patentable. So it really is important that there be a strong economic reason for filing a utility patent. It is so costly and so time consuming that, as a patent attorney and, a friend, I would say, make sure it's a good idea. Make sure that there is a financial reason to do so. And so, again, it takes from 3 to 5 years from the filing date to have an issued patent. I've worked on some that have taken as long as 10 years. The process is that day 1, the application is filed. 18 to 36 months later, an office action is presented from the Patent and Trademark Office to the counsel or to the inventor. And that's when you start the back and forth to negotiate whether your patent is, or whether your idea is patentable. Yep, there you go. It just goes on until the case is allowed, appealed, refiled, or abandoned. Benefits of patent ownership. Once the patent issues, what can you do with that patent? You can license it. Again, patent gives you the right to exclude others from doing things. You can license that idea to others so that they can practice your idea. You can litigate to obtain substantial damages. So if someone else decides to steal your idea, practice your patented invention, you can approach them, say you want to take a license. If they say no, you can choose to litigate. And last, if you just so choose, you have that right to exclude. You can say, you're a competitor. No, not enough money in the world. Stay out of my realm. I'll stay out of yours. And you just exclude them from doing so. Here are some of the disadvantages of patent ownership. Again, the cost to obtain it, up to $25,000, sometimes more. If you're going to spend that type of money, you should have the desire to enforce it if the time comes. As your patent attorney, I would suggest, you're going to spend that $25,000. If someone comes along, they're going to steal your idea and you're just going to roll over. So how much does it cost? It is enforcing a patent, and you all are in Longview, Texas. You are in the patent hotbed of the United States. It's called the Patent Rocket Docket in the Eastern District of Texas, primarily Tyler, Longview, Marshall. That's where a large number of the patent lawsuits are filed in the country today. Less than there were a few years ago. The Supreme Court has issued some rulings on where you can sue someone. Most people wanted to sue here, the plaintiffs, the patent holders wanted to sue here in the United States, or in the Eastern District, excuse me, because damages were high, juries were reasonable, and tend to get good rulings as a patent holder. So everybody wanted to file here. I would say, I'm just guessing, but a third of the patent lawsuits in the country were being filed in Tyler, Longview, or Marshall. So what does that make for? It makes for lots of litigation, lots of attorneys. Most of those attorneys are just litigators, not all of them even patent attorneys, but in any sense, lots of litigation here. But average cost can be from a couple $100,000 to $1.5 to $2.5 million per party, and that's on the low side. If it's a game-changing technology, something core to a company. I was just involved in a 7-year litigation that I would assume $40 million in legal fees were spent. So it really does just depend. But yeah, I can guarantee this. You'll be in for a couple $100,000. If you want to extend it, it'll be $1 to $2.5 million. So there are options for that. If you're the patent holder and someone's stealing your technology, there are attorneys out there that will work on a contingency fee basis. So maybe if you cover the out-of-pocket expenses, they might help you with the legal fees, and if they recover money, they get a percentage. But again, yes?
How often have you seen a big, major company or corporation that has a lot of wealth just out-litigate someone, even though they might not have been in the right in terms of the actual law? They can out-litigate somebody and use their idea and get away with it because the person can't afford to fight it in court.
Well, on that point, I would say large corporations respect intellectual property. They have their own intellectual property. They respect that. They respect the intellectual property of others that are true innovators. But there's something called a non-practicing entity. You've probably heard of patent trolls. What is a patent troll? A patent troll is, so they were initially termed patent trolls, and they tried to change their name to non-practicing entity because a patent troll sounds bad. I mean, obviously. And so these non-practicing entities, all they do is they go around and buy up patents. They don't invent them, they purchase them. They don't manufacture anything. They're just a patent holding company. And they go out and enforce these patents against large corporations. Well, when it comes to those scenarios of a non-practicing entity, you can see which side of the coin I'm on. But that a non-practicing entity sues a large corporation, yes, it happens all the time. Large corporations we will wear you down, we will spend so much money that you're not going to survive. I mean, there are non-practicing entities that have really good patents, and they're not about trying to just shake the leaves and get a couple $100,000. I mean, it's real technology. And in those circumstances, both parties will fight. They'll both spend lots of money. And more times than not, they'll come to an agreement. They'll settle that lawsuit. There have been some very large awards here in the Eastern District. Apple and Microsoft have had some. There was an Apple and I4I lawsuit that I think the damages were $450 million. There have been a couple of those. And knowing counsel on both sides of that, Apple's thought is, we will string this out as long as possible. And I4I is like, we don't have that much money. We can't keep going much longer. But when you have a $450 million pot of gold at the end of the road, you keep fighting. And that one was just ruled maybe in the last 6 months that I4I did indeed win that lawsuit. And so you have to go up all the way through appeal. And probably at some point they're going to settle, or rather than paying them $450, I'd guess $250, $300, whatever, lots of money. But yes, now when it comes to two competing companies, say Apple against Samsung, they've had some big lawsuits. Money is not a problem. They will devote as much money as necessary to enforce their core technology against a competitor. So hopefully that answers your question. It just depends.
What would happen if like you said, it took like 7 years to litigate. What happens if the patent time runs out before the litigation completes?
It's a good question. You are entitled to obtain damages 6 years back. So if I brought a lawsuit today and whoever I was suing knew about the patent, I could go back and get damages for 6 years. So for your example, you can go back 6 years no matter what. So you can even file a lawsuit after the patent term is run. So you can go 6 years forward. So 6 years after the patent term had run, you could go and collect damages. Does that make sense? Hopefully that. So essentially, you are losing term on your patent as you're trying to enforce that. But at the same time, you can collect damages during that 7 years, and you can collect damages 6 years prior to that. So in the situation that I'm discussing, if there were damages, we've litigated for 7 years, and we can go 6 years back from when we first brought this lawsuit, you can collect 13 years worth of damages there. Now, if we had an extra patent term going, once it's complete at 7 years, there's an agreement in place, there's a judgment by the court, they're going to have to keep paying me moving forward if I was a patent holder and won. So hopefully that answers that question. But again, you cannot enforce, one of the drawbacks, costly to enforce, you can't enforce it until the patent has issued. You have a patent application, you cannot, there's no intellectual property rights. That's like saying I want to buy someone's home. Until you own that property, it's not yours. You do not have the intellectual property. You do not have the patent until it issues. So you can't enforce it until it does. There are mechanisms where, to your damages question, that you can go backwards after your patent is issued. You can go, after it issued, you can go backwards in time to get some damages. But that's if you have marked it and the claims haven't changed much during the prosecution. That's probably a little bit over your heads, but that's what we're talking about right here. Another drawback, you have to pay maintenance fees. These patents are not inexpensive to obtain. They're not inexpensive to maintain. Once your patent is issued, you have to pay a patent or a issue fee, and then at 4, 7, and 11 years, 4, 7, and 12 years, you pay these fees to the Patent and Trademark Office. They're exponential. Might be $1,000 at the first term, $2,000 the next, and $8,000 the next. Again, if you're not using that patent, take a step back. I love having these patents, but does it make sense for me to pay that second term or third term? Now we're going to talk about design patents. And at the end, I'm going to try and press through pretty fast. We can come back and answer any questions about utility patents, because I think that that's one of the more important aspects of this discussion. But there are design patents. Utility patents protect the function. Design patents protect the general look and feel, the ornamental appearance of the article of manufacture or machine. Utility patents, 20 years from first filing is your term. Design patents, you have 15 years from when they issue. Okay? Design patents also do not have maintenance fees. So those expensive maintenance fees, not the same for design patents. Design patents are, if someone were to come to me with a design patent, you would prepare a bunch of drawings. You'd show each of the views, top, bottom, left, right, back. I mean, every view of the idea, because you are trying to patent the ornamental design. Again, it's a much smaller document, does not require as much attorney's time. Those claims that I talked about in the utility patent, a claim of a design patent is the ornamental design as shown above. You may have 20 drawings. So you will spend typically as much, sometimes more, on the draftsman fee, the electronic draftsman that draws the drawings and puts them. I mean, a lot of times someone will have just a hand sketch of here's my idea, or some photos of something you may manufacture. So getting that onto paper and presenting those to the Patent and Trademark Office through the draftsman can almost be as much as the attorney's time in a design patent. But you can use patent pending once it's filed. So basically it has the same advantages and disadvantages as a utility patent. So the cost of a design patent is less, not only to get on file and get to issuance, but also it costs less to enforce. The analysis that one might go through to determine whether someone infringes a utility patent is PhD engineers or chemists, fighting back and forth about what this one word means. And after that one word, after you determine what the one word means, does this product have that feature that's described in that one word? Design patents, you basically just compare your patent. So take, for example, you put your patent in the middle, put the closest prior art on one side, and put the device that's alleged to infringe on the other. You just say, is this middle one closer to the prior art, or is this middle one closer to the infringing product? If it's closer to the infringing product, they infringe. So it doesn't go, you don't have these, high cost expenses, the experts and such for design patent law. So again, it is much easier to enforce. You can file a foreign application based on a design patent, but you must do so within 6 months from the U.S. filing. When you want to file a foreign application on a utility application, you have 1 year to do so. And again, the design is not patentable if it's purely functional. We're looking to the general look and feel. Plant patents, I'll be honest with you, I can tell you that you have 20-year term from the earliest effective filing date. There are no maintenance fees. Myself nor my firm do them. Don't know much about them. They're very rare. People focus their entire lives on plant patents, and all the plant patents, people that are wanting to patent plants generally go to those few people who do it. Moving on to trademarks. So trademarks, you have federal trademarks, you have common law marks. So a federal trademark is essentially, you obtain it by filing an application for registration. It's based on either actual use in interstate commerce or applicant must have an intent to use. So essentially you have a company name, a slogan, a phrase that you want to trademark. Coca-Cola. They have a trademark on the name Coca-Cola. They had to show, one, that they were either using it in interstate commerce when they filed it, or they had an intent to use it. There you go. Common law mark. So even if you're not using it in interstate commerce, the moment you use that frame, you will have a common law mark. So rights are acquired by use of the mark in connection with the goods or service which move in commerce. It does not have to be interstate commerce. So for example, you're someone in Longview that is starting up a new company, and they're going to provide the services of X. And some of their clients may come from Dallas, some may come from Tyler, some may come from Shreveport. We cross the state, interstate commerce. We could file a federal trademark there because either they have an intent to go across those state borders or they have. Now, if it was just a little bitty company in Tyler that does no business outside of the state of Texas, they would have a common law mark and would not be entitled to a federal trademark. So to determine whether there's infringement in trademarks, you basically look, is one that is likely to cause confusion among consumers as a source of goods or services. So essentially, are you trying to take from the goodwill of one name to benefit yourself? I remember growing up, had a pair of sunglasses that I bought 35 years ago. Had these beautiful sunglasses that I saw that were being sold in a little town I grew up in at a little shop, and they were Coca-Cola sunglasses. They had the Coca-Cola name on the side. Looked a little closer, and it was not Coca-Cola, it was Coca-Cola. Again, that's all they're trying to do. They knew that they couldn't use the word Coca-Cola. They changed it up a little bit, trying to use from the goodwill of Coca-Cola and really steal that sale. I didn't know it until I looked closer. So the process. So application is filed and the examiner's response is usually received within a year. Remember, patents, 3 to 5 years. Trademarks, about a year. Applicant can file those same responses and can go back and forth trying to get the trademark allowed until it's either allowed, appealed, or abandoned. Once allowed, the mark is published in the official gazette, and after 30 days and no one's opposed your mark, you're entitled to that trademark. So, say for example, someone were to come along and try and trademark Coca-Cola. Coca-Cola would have 30 days, sorry for that, would have 30 days and in which to oppose that mark. I can assure you that Coca-Cola would. Same goes with Apple. These large corporations, they will just search and search and search for people that are trying to just do little offshoots of their names, trying to steal product. Apple is one, not a client of mine, but when you talk about wearing people down, Apple is key when it comes to their trademark infringement. People that are trying to, iPad, iClock, anyone that puts an I in front of something, an article, they're going to come after you. They really will. I had a client in Dallas that was a manufacturer of kitchen products. Had all these really neat kitchen products. It's been around for plastics. They're a plastics company. Been around for 45, 50 years. Had an Apple with a little bite out of it that they had been using to sell kitchen products many years ago. Apple learned of it. Came knocking on the door. You can't use that. We're like, we had that Apple with a bite well before Apple did. We disagree. And we made a quick decision that it was not worth it. Could we have won? Should we have won? Yes. Did we want to spend the millions of dollars? No. So, to your question, yes. In trademark, that really does happen. If the opposition is filed, the examiner process is stayed until an outcome of the opposition is determined. So, again, that opposition is someone coming and saying, no, you're not entitled to a mark, and it can be expensive. There's a discovery process. It's like a mini trial. After opposition, the mark is either allowed to proceed to issuance or the application is abandoned. Cost for filing a trademark, $1,300 to $2,500 relatively in that range, and every response might cost around $1,250. Again, this is small potatoes compared to the patents. Now, if you are going to do that opposition, you're talking many thousands of dollars. Patent lawsuit, many millions. Opposition trademark, 30 to 80,000 roughly. I've been using the term trademark. That's like saying, does anyone want a Coke? Oh, what type of Coke do you want? Well, I'll take a Dr. Pepper. Trademark is a general term that is used to cover both trademarks, per se, and service marks. Trademarks cover goods. So, for example, Post-it notes. Someone's selling Post-it notes. They're selling a good to you. That's a trademark. Service mark, FedEx. They're not selling you any goods. They're selling you a service. So that's a service mark. You also have certifications and collective. You see those there. Not as common. With the marks, trademarks, you can have the actual word, so Coca-Cola. You can have a phrase, it's the real thing, or you can have a design or symbol. It's a logo. Your name does not always have to be in the logo. They could have this without Coca-Cola and still get a trademark on the logo itself. That little logo right there for our firm. I don't know if you can see it, but there's a P in blue there, and that's a J for P and J. We could get it on just that logo. We could get it on the whole, logo with the name. We could just get it on our name. So, again, we sell services, legal services. We would be a service mark. If you want to show how to, after you've gotten your marking for trademarks, federal, Circle R, common law, TM for trademark, common law, service mark, SM. Benefits of registration, again, you don't have to, yes?
Yeah. How important is it to always put the little R or TM next to things when you want to protect it?
TM, not so much. R, you want people to know this is my name and don't mess with it. I've spent money. I've filed for a federal trademark. I've obtained that federal trademark, and this is mine. So that they know, it's kind of a notice provision to let them know that, stay away.
Also, if you update your logo, do you also have to update, how did you update the registered trademark?
Well, you cannot update a trademark.
Okay, so you
You
have
file a
to
new one.
file for
Yes.
it.
So, once you file it that one time, and trademarks you file within classes. Coca-Cola, when they originally filed their trademark, it was for a beverage. There's a class for beverages. Well, again, then they started selling shirts. Well, there's a different class for shirts. When they had initially filed, they didn't think, hey, we're going to be a shirt company. So they had to refile the word Coca-Cola in every class that they came upon. They were selling pencils. That's a different class, and they would have to file there. So as your business expands, you may need to have additional filings in additional classes. So again, trademark gives you a nationwide right to exclusive use, prima facie evidence of ownership, and after 5 years, no one can contest that trademark. It is golden. And it gives you the right to bring suit in a federal court. Yes?
So would the different classes trademark thing, that would fall underneath the 30-day period where you get to contest?
Yeah, each one that you file, if it's in a different class, then after it's issued, you would have 30 days to oppose that.
All right, so if someone tried to create Coca-Cola pencils,
Right.
then
Yep, you would have, and again, there are search companies out there you can pay for services that will just scour the world looking for people that are just got a little offshoots on your name. Copyrights. So copyrights, trademarks, patents, all different things. Copyrights are basically you're protecting expressions fixed in any tangible medium of expression. You're sitting at a table, you sing a new song, you write it on paper. The moment you put it on paper, you have a copyright on that new jingle, like you said. You don't have to file for anything to have a copyright. It is just the moment that you fix it in a tangible medium, you have it. You know, that's just the way things are. You say have a new little poem that you're writing to your child or mother or girlfriend or boyfriend, whatever. Put it on paper, hit save, bam, you've got a copyright. Now, to enforce it, you do have to use the court system, and it's best to file for a federal copyright. The duration of a copyright is the life of the author plus 70 years. If it's a work for hire, so if you hired someone to do that for you, to paint you something, it's 95 years from publication or 120 years from creation, whichever is less. Copyrights do not protect titles, names, individual words, short phrases, and slogans. Most of those are trademarks. Ideas, procedures, methods, systems, processing, concepts. Those are patents. Facts, including sweat of the brow, an alphabetic compilation of names and dollars. No copyright to that. Works consisting of public domain information and containing no original authorship. So tables and blank forms, stuff like that. You don't get a copyright for that. So under 17 U.S.C. 106, the exclusive rights, again, patents, gives you the right to exclude others from making, selling, using, offering for sale, or importing. Here, gives you the right to reproduce. So it is giving you the right to do things. Before it was the right to exclude. You have the right to reproduce copyrighted works. You have the right to prepare derivative works, so those are modified works. Distribute copies of the copyrighted work. Perform copyrighted work publicly and display copyrighted work publicly. So again, copyrights are a little different than patents. Patents you have the right to exclude. Copyrights you have the right to do. Benefits of the exclusive rights, you can prevent, and you have the right to exclude as well, you can prevent others from copying, prevent the distribution. You can seize illegal copies. Copyright law does have a criminal aspect to it. If you steal someone's technology enough, they can go after you criminally. Patents, trademark, it's all civil stuff. So you can seize the illegal copies, you can prevent importation, and you can prevent someone from creating a derivative work. So how do you notice up a copyright? Best place, see with circle, date, name, just like you see right here. Limitations of copyrights. So we talked about that. Doesn't protect ideas or facts. How close is someone's copy to yours? It's up for debate. If you kind of try and steal someone's idea, wow, that's a little different. No, it's kind of the same. Really what they look to determine whether there's copyright infringement is, was there access? They can show, hey, yours looks a lot like his. and you bought a pair of my son. I was doing a lawsuit on fancy kind of reader glasses that you might find at a TJ Maxx. They had these pretty designs on the side. There was a knockoff company. They changed it up just so much. I don't know. Does that look like ours? Yeah, pretty much. Well, we had an order from a Chinese company that we were suing for one copy of every design we had. Well, now they had access, and we could connect the dots and, hey, they bought it, they copied it, they changed it up a little bit. All right, you got copyright infringement. So there are some fair use provisions which allow persons to copy, display, or use portions of a copyrighted work under certain conditions, education, so on and so forth. Factors used to determine fair use, the purpose and character of the use, including whether such use is of commercial nature. I mean, if you're not trying to steal someone's glasses and go make money of yourself, is it really copyrighted? Is it a fair use or not? The nature of the copyrighted work, the amount and how close the copy is, and the effect of the use upon the potential market for or value of the copyrighted work. So is it having an impact? Yes.
So how does that affect prosecution in terms of a copyrighted work with parody and that coupled with commercial and non-commercial use for parody?
Help me with that again.
Parody, like say someone made a parody of a song or something like that, but the song's already copyrighted.
Right.
So could they, under fair use, make a parody of a song and sell a parody of that song?
Well, once you start selling it and commercially benefiting from that, then the question would become, is that outside of fair use? And then you would look at how close is it related to other items. So, the question becomes, fair use is apart from infringement. Okay, it is a copy. Have one hat on. Two, is it fair use? And I would say in that situation that if they're trying to make money on it, it would not be fair use. So trade secrets. Now we're just heading down the line. Patents, in my mind, most important. Trademarks, second most. Copyrights, next most. Trade secrets might be next most, but when you're thinking of individuals and corporations, it's kind of that order. Trade secret. You can protect just about anything with a trade secret. The Coca-Cola, how to make Coke. That is a trade secret. They have done a fantastic job of keeping that a trade secret. 2 people know at any one time. 3 people, whatever it is. But they have done a fantastic job. To be a trade secret, it must be generally known, must not be generally known, or readily ascertainable from independent sources. Again, you have to take steps to keep that a trade secret. Texas courts look at the following and determine what is a trade secret. The extent to which the information is known outside the employee's business shouldn't be known at all. If it's a secret, it's a secret. The extent to which the information is known by employees and others involved in the business. Again, if you have a trade secret, you want to keep a tight group of people who know that information. You don't want to tell every employee that. Employees come and go. Let's keep it at the top of the management. The extent of the measures taken to guard the secrecy of the information. Are these employees under a non-disclosure agreement? Are there any, if they do disclose it, what are your ramifications? You also look at the value of the information to the business and its competitors. Again, back to Coca-Cola. That's one of the best trade secrets ever known, is how valuable. Well, if everyone can knock off the flavor of Coke, that company would be nothing. The amount of effort exerted in developing the information and the ease or difficulty to which the information could be properly acquired or duplicated by others. Misappropriation of trade secrets. To show that there's a misappropriation, you have to first establish there is a trade secret. 2, the trade secret was acquired through a confidential relationship or through improper means. The trade secret was used or disclosed without the owner's authorization, and that damages resulted. I'm going to kind of jump through some of these. Trade dress. One of the last ones. Trade dress is very much, it's almost a combination between trademarks and design patents. It's essentially a physical feature on something that would be used to denote this is my company that manufactures, sells this. So it can be invoked when it is believed that a consumer would likely be confused and be used to preclude competitors from copying the shape or appearance of a company's product or packaging. The dress must be functional, non-functional, and, like a trademark, must serve the purpose of denoting the source. Trade dress, examples of trade dress, the shape of a Coca-Cola bottle, the initial Coca-Cola bottle. The front grille on the Rolls Royce, shape of a classic Ferrari sports car. The round wall thermostat by Honeywell. Not sure how that deals with Nest these days. The shape and appearance of the Big Bertha Golf Club. You know, if anyone, as a group of engineers, hard scientists, if anyone's interested in ever becoming a patent agent, patent attorney, to do either of those, you have to be a U.S. citizen or reside legally in the U.S. 2, you must complete an undergraduate degree in a scientific field. There are some ways around that if you have enough hard science or core science classes, and you can establish that. But the easiest way is you have to be an engineer or scientist by undergraduate degree or graduate. And that's the first step. You cannot be a patent attorney or patent agent without those. You also have to meet a good moral character, no felonies. And then if you want to be a patent attorney as opposed to a patent agent, you need to graduate from law school and pass the state bar exam. Last and most important, if you want to be a patent agent or patent attorney, you have to pass the patent bar exam. I can't tell you how difficult that exam is. In the state of Texas, the average pass rate for the attorney's bar exam is 70-75%. When I took the patent bar exam, the year I took it, it had like a 16% pass rate. I think it's up these days, and now it's online. You used to have to wait. You could take it once a year. Now it's online. You can take it via computer. Yes.
Did you pass the first time?
I passed 75% of the first time. I only had to go back and pass the last quarter of the second.
Interesting.
Yep. So it had 4 parts, or maybe it's 3 parts, and I passed 2 or 3. But anyways, I know I sped through a lot of that.
That's a good segue though. If you're interested in taking the patent bar exam, Turner now offers a course on political science 3223 called Patent Law for Scientists and Engineers. And it's a course designed for engineers and scientists who are interested in patent law or preparing to take a U.S. patent office bar exam. So with that, let's thank our speaker again.
If you have questions and want to shoot me an email, I'd be happy to spend a little time answering them. Just let me know that you're here. Here's my email address. Make the connection between the Turno, and I'll be sure to answer. Absolutely.
Out of curiosity, if a mom and pop shop decides to do online business, does that automatically count as interstate, or does somebody from outside the state need to buy something online?
So online, interstate depends on whether it's a service mark or a trademark.
Okay.
If it's a trademark goods, that online is enough for the interstate commerce. If it's for a service, it is not.
Oh.
Does that answer? Yep.
Yeah, so does online, because I know online
Right.
business has really changed things, so does online businesses usually go more for the federal trademark just because?
If you can, yeah. You always want the federal trademark if you can. Because if you have a common law mark, it's only in that region. So if you're using your mark only in Longview, you have the mark to exclude others in Longview. If you have the federal, it's around the entire United States.
So, concerning patent law and international, so if someone has a patent in, say, Europe or China, and you have a patent here in the United States, since you say that, for example, correct me if I'm wrong, it's
The novel and non-obvious? Is that what you're?
No, it's the first type.
Non-provisional.
Yeah, non-provisional. If it's a non-provisional patent, you said that it essentially restricts someone from producing. So would it restrict someone from producing outside of the country or in your country?
Again, you're entitled to a patent if it's novel, no one's done it anywhere in the world, and not obvious. It's not obvious anywhere in the world. You file your patent in the United States, you're able to exclude